Good afternoon, Mr. Laing, and you must please tell me if I'm pronouncing your surname correctly.
Yes, you are, Chief. Good afternoon.
Yes. Okay. How are you this afternoon?
I'm fine, thanks. And you?
No, I think I'm all right.
Yes, that says a lot.
I apologize on behalf of all of us that we have kept you waiting for longer than you should have.
That's understandable.
Yes. I thank you for availing yourself for consideration for appointment as a judge in the KZN division of the High Court. We appreciate that. I'm going to ask you some questions, and after I'm done, I will ask the acting judge president to ask you questions. Thereafter, it will be the MEC who represents the Premier, and then I will allow commissioners to put questions to you. But all questions will be put to you with a view to commissioners seeing how your appointment, if you were to be appointed, would comply with the selection criteria that this body has adopted for assessing candidates for appointment. You understand that?
Yes, that's understandable.
Yes. I see that you hold 2 degrees, BA and LLB, both from the University of Natal. Is that correct?
That's correct.
And I see that you then have a diploma in theology.
That's correct.
And you are also a conveyancer.
Yes.
And you have undergone judicial skills training with the Law Society of South Africa.
Yes.
And you have a certificate in insolvency that you obtained from the University of Pretoria.
Yes.
You have also done divorce mediation.
That's right.
Yes. In 2014, you did an introduction to commercial law offered by the Law Society. Is that right?
That's right, Chief.
Yes, you got your BA in 1981 and your LLB in 1983.
Yes, that's correct.
Yes. But I also see that at some stage in the early 80s, you were a librarian at the University of Natal.
Beg your pardon? Beg your pardon?
That I am saying, I see that in the early 80s, you were a part-time librarian at the University of Natal as well.
That's right, yes.
Yes. But you did your articles from 1983 to 1984 with Farouk Vahed and Company, and you, after your articles, you were admitted and you became a professional assistant in that firm.
That's correct.
And then you, in 1986, you established your own law firm, which you called Laing and Frank.
Yes.
You were in partnership with somebody.
Yes, that's right, yes.
Yes. And you then later on became Laing, Frank, and McDonald.
That's correct.
Have you been practicing as an attorney since then, or has that changed?
Yes, I have been practicing as an attorney since
then?
Since 1985, yes.
Yes. And in 2008, you went back to, or you became a sole practitioner, you established Laing and Associates.
That's right.
Yes. And then you have written here under the chronological particulars of employment since leaving school or university, you have said name of employer, Department of Justice, position held acting judge, and then period you said in 2015 to 2021.
That's correct.
I assume that 2015 to 2021 is incorrect because probably it was different periods during that period and not continuous.
Yes, every year I think it was a session from 2015, except in 2021 there were 3 sessions that they acted for.
Yes, but that doesn't mean it is continuous,
No,
does
no,
it?
it's not continuous.
Yes, but the way you put it here creates the impression that it was continuous.
Oh, I see, okay.
Because you said, you see, the heading of the questionnaire is, please furnish chronological particulars of employment since leaving school or university. And then you have written, and then it says name of employer, position held, and period. So you have set out names of your various employers over that period and the positions you held during that period and the periods when you were employed by those employers. And then
Yes, I see that.
you have then said Department of Justice, acting judge, where it says period, you said 2015 to 2021.
Yes, it can be confusing.
That says, actually it's not even an impression. It says from 2015 to 2021, you were employed as an acting judge. That's not correct.
That's not correct.
Okay. What were the periods of your acting stints?
It was in 2015. Let me just,
Or maybe you can just say how long, how many weeks or months?
Oh, it worked
in
out about
2015, how many weeks or months?
Yes, it worked
the
out to
other
about,
years?
sorry, it worked out to about 47 weeks. It worked out to about 47 weeks.
47?
Yes.
Yes. Okay. Now, tell us about the nature of your practice, the types of cases that over the years you have been doing in your practice. What types of cases have you been dealing with?
Well, initially it was
Commercial work, administrative law work, constitutional law work, labor law work, competition law work, delict, collections, aviation, patent law. What kinds of cases have you been doing?
Yes, initially it started off with collection work as an article clerk, and then it moved on to delictual work, which involved motor collisions, RAF claims, including, and then went on to, it was just added on family law, divorce law, and maintenance, and those sort of issues that were involved in the family. Then there was a major portion of my practice was crime, at least in the first 20 years. And as time went on, the scope grew into conveyancing, estates, because how it worked out when we formed that partnership, there were divisions. I dealt mainly with the criminal law side of it, and the other 2 partners had their own fields of law. But when the partnership collapsed, then what happened, everything was left on my shoulders, so I completed my conveyancing course to catch up with all the other conveyancing that was left behind, and I started doing estates and doing family law, a lot of that, more civil work than criminal work, actually. The conveyancing was a bit limited. I wanted to get involved with insolvency as well. I did the courses with insolvency, but not much came of that. I still get appointments every now and again from the Department of Justice. I think that's about it.
Yes, I see that in the questionnaire you said that at some stage your practice consisted of 15% of criminal work, but you said you no longer do criminal work.
Not as much as I used to, yes.
Yeah, you used to. And administrative law, you said 2%, constitutional law 0%, labor law 3%, insolvency 10%, administration of estates 20%, contractual stroke commercial 10%, personal injury 30%. So that's how that's the picture that emerges from your practice in the past.
That's right.
Yeah. Did you do trials, civil trials as an attorney in courts, both magistrates' courts and high court?
That's quite correct. CJ.
Do you still do them as an attorney as opposed to sitting in court as an acting judge?
Yes, I still do them. Most of my cases were done by myself as opposed to briefing counsel. Most of the size of my practice.
Do you do them in the high court as well?
That's correct.
And motion court, do you appear in the motion court
Yes, I appear
as an attorney?
In motion court regularly as well, yes.
And are there any cases that you have, in which you have been involved as an attorney that have resulted in reported judgments?
No, Chief Justice. No, nothing. Apart from Safley and those type of cases where they just had a report, but nothing major.
Yeah. And as an acting judge, are there some judgments you have written that have been reported?
No.
Okay. About how many written judgments, more or less, have you produced as an acting judge up to now?
I didn't count, but I would assume, I was trying to work it out this afternoon, but I think it would have been about 20 to 30 at least.
About 30?
Yes.
At least. Okay. And in the High Court, when you were acting, you also sat in full bench appeals?
Not full bench, just ordinary.
You did not sit in full bench appeals?
No.
Did you do opposed and unopposed motion?
That's correct.
How much of it did you do?
Well,
like how many weeks, for example, have been taken by motion court?
Every week you sit in motion court. So not every week, it's one session. Every session you at least do one a motion court.
Yeah.
So I started doing mainly civil stints since 2018. So prior to that, I was doing mainly crime. 2018, 2020, 2021, I would think I would have had about 4 or 5, say 5, I think, motion court stints.
Yes. What is your understanding of what the rule of law is?
Well, I think it's there to restrict the arbitrary abuse of power by any individual. No one can, no matter what your position you hold in society, you can't take advantage of that position. So the rule of law is there to protect any other individual against that abuse of power.
And what is the doctrine of the separation of powers?
Government, I think it can be explained by saying it's the division of government into branches, which is the legislature, executive, and judiciary. And the purpose, I would think, of that division is to prevent any conflict between the three of them.
What is the independence of the judiciary?
Yes, the judges and the judiciary are independent in the sense that they cannot be influenced. They're not allowed to be influenced. They must apply the law as it stands in relation to what is presented before them. So whatever case comes before them, they must apply the law strictly as it appears in our statutes, without any favor to any particular person or organization.
Yes. Acting Judge President, I give you the opportunity to put questions to the witness, to the candidate.
Thank you, Chief Justice. Mr. Laing, I'll put some questions to you. So, according to your assessment, are you now ready for permanent appointment as a judge?
Yes, Chief.
So, on what basis do you say that you are now ready?
I've had 35 years at least of practical experience. My law practice has mainly involved the application of law, sitting and acting in courts of law, involving litigation in particular. I've sat for the past approximately 7 years, I think it is, from 2015 to end of last year, as a judge, doing legal work and full-time legal work. There's been no separation or division of those periods doing something else. So I believe I'm fully qualified and have the necessary expertise to sit as a judge.
So you don't feel that you are somehow need an exposure, more exposure?
No, Judge. I feel I'm fairly qualified. I may add that initially when I was asked to act, I wasn't too sure of myself. I felt intimidated, but I spoke to the leadership of my organization and they said, I must go for it.
Are you aware of the application proceedings?
Of the?
Pending application proceedings is pending against you.
Yes.
By Mr. K. Naidu and Mrs. Naidu, in which they seek an order compelling you to deliver to them an original or certified copy of the title deed in respect of any movable property they purchased from you in 2012.
That's correct.
And the payment of the interest accrued to them before the transfer of the property in question.
Yes, I'm aware of it.
You're aware of it.
Yes.
When did you first become aware of these proceedings?
They instituted proceedings in 2021, and the sale, I was the executor in an estate, and I sold the property to them in 2012, it was.
Yes.
And
But you did not disclose them, these proceedings in your questionnaire, did you?
No, I did not.
Why not?
Well, it didn't crop my mind, actually. I didn't think it was necessary, number two. Number three is that I have other cases where I'm the plaintiff, so to speak, and those cases are mainly where it arises out of the collection procedure of debt owing to the firm, so that's where I'm the plaintiff. And there's also cases where I'm put up as the defendant or respondent in insolvency matters where I'm cited as a trustee, NO, nomine officio.
Okay, but in this application, the applicants alleged that they have since 8 August 2013 been appealing to you to deliver the original or certified copy of title deed and to pay them the interest owed to them with no success.
My Lord, the position is that the title deed was delivered to them, I think, but they have no actual proof. If one looks at the document on page where it's marked served, let me get my, where the document was served on them, and then what happened was he disputed that it was served on him. So I undertook, because he's a colleague as well, I undertook that I'll apply for another copy of the title deed and deliver it to him. I prepared the papers in terms of the regulation for him to sign, for the affidavit to sign, for him to sign to suggest that the title deed was lost. He refused to sign the title deed because this was all done at my own cost. Then I prepared another affidavit suggesting that we had lost the title deed as he insisted. But he still had to sign the affidavit because it's an affidavit that he's got to put up in any event. And that's, everything just fell apart. Nothing was happening from that date. I think it was 2014, 2015 or so. And only now, a year later, that's 7 or 8 years later, does he bring this application against me for me to hand over the title deed. There's no reason for me to keep his title deed. There's nothing I can do with it. If you look at KN6 on page 51 of the papers, I'm looking at my file actually. I'm not too sure if it's 51 of his. Affidavit, the regulation provides for an affidavit to be signed in order to get a copy of the title deed. So I undertook to do that for him. The correspondence, if you read through as well, shows that I did do so. I undertook because I felt, he's a colleague, let me take the responsibility of giving him the title deed. So nothing of that was done. In dealing with the interest, I sent him the bank statements showing how the interest has arisen. And that ties in with the money I paid him. And then he denied that I paid him. He states under oath that I didn't pay him. So I had to go and search through my archives again to find the check and the bank account to show that I paid him the interest.
Okay. Is it correct that they could not register the transfer of the property in the absence of the original or certified copy of the title deed?
Yes, you can't do that. You need a certified copy of the title deed in order to do so. So if you wanted one, you could have applied for one or insisted or asked me to continue applying and make the necessary advances to ensure that he gets the title deed.
And they further alleged that at some stage you withdrew an amount of 10,000 rand from their investment account without their authority.
Commissioner, the position was that he did not pay the transfer costs. We sent him a pro forma account on the 12th of April 2012. So he received that account because he puts it up in his papers that he got that account. And that account was sent to him asking him to pay the pro forma account. Now he denies that he received the pro forma account. So what was suggested to him that we would use these monies. So those monies that were in savings were transferred from savings into a trust account to pay for the costs. So that's how it came about that the 10,000 was used. And thereafter, another 35,000 rand was transferred from savings into his trust account to pay for the other expenses. So what he didn't do, he didn't pay the pro forma account. And so it was agreed that we would use the interest from those monies to set off the payments of the pro forma costs.
So were they aware of this?
Yes, he was aware of it. Because he didn't, if he had paid the pro forma account, that would be something different. Because then I would have not taken the money without his consent. The mere fact that he did not pay the pro forma account shows that we had agreed that we could use those funds. He was also aware that the estate was bordering on insolvency. So the position was that we could not use monies that were in the estate to pay for the arrears.
So is it correct that to date we have not delivered the
title deed?
The title deed?
That's correct. I've told him in 2014 already it's lost, it's mislaid, somewhere along the line. We don't know what happened to it. Our notes suggest that it was delivered to him, and we, out of goodness of our hearts, decided that we'll apply, and to apply for the title deed, a duplicate copy of the title deed, and he didn't bother about it. I don't know for what reason, and I thought perhaps maybe over the years that he had got someone else to attend to it.
So would you think it will be appropriate for the this commission to recommend your appointment whilst you have this proceeding hanging over your head?
Yes, it is. You know, proceedings, civil proceedings in particular, I think we all face them at one stage or the other. So there should not be a bar to my appointment as a judge. The mere fact that this matter has been lying stagnant now I've just asked my attorney to find out what's going on with this matter. And nothing's been proceeded with since last year, since June, I think it was. That's the last time he put up his replying affidavit, if I'm correct. So I've asked him to have the matter sit down and finalized so that we could get this off the roll. I may also add that he in fact owes me, because that 10,000 that was paid over into the trust account, I receipted. Sorry, not I receipted, but my secretary receipted as a deposit from him. Meanwhile, it wasn't from him, it was from the savings account that was transferred into trust. So it shows it as a receipt in trust. So when the final accounts were done, I gave him credit for the 10,000 rand. With the result, I was not paid my conveyancing fee.
Okay, thank you, Chief Justice.
Thank you, AJP. Unfortunately, I couldn't hear exactly everything, and yet the issue that the AJP was asking you about seems to be quite serious. I'm just going to ask you specific questions and ask you to respond very clearly.
Certainly. I think maybe I should come closer to the mic.
Is the position that a former client of yours or somebody for whom you did some work as a conveyancer has lodged proceedings against you for you to deliver the title deed of some property?
That's correct.
And when
Chief.
were these proceedings launched?
Last year, in April 2021.
Were they by way of an application?
That's correct.
In the High Court?
In the High Court, yes.
And are you opposing the application?
Yes, I've opposed the application, and he's put up
an answering affidavit?
That's right.
And pleadings have been closed?
That's correct.
And did you give them the title deed? Did you not give them the title deed?
Commissioner Chief, the position was we had delivered it. We had a note indicating that we had delivered the title deed. Served on, it doesn't say to whom, it just says it was served on him. Not on him, but it was served on a particular date.
How would it have been served? I guess you being the conveyancer, you should know to whom it was given.
Yes, it doesn't bear any signature. It shows served on the 14th of November 2013. If you look at page 113 of the bundle, you'll see there it was served on that date. Now, subsequent to that, if you look at the next page, BSL 2, I asked him to check with security to find out who came to his chambers on that day, to find out, because if in fact they came on that day, the security at Salmon Grove Chambers takes down the name of all people that come in to visit council, and would show then who dealt with the delivery of the title deed.
Who in your firm had you authorized to give the title deed to somebody? Did you authorize somebody in your law firm to give the title deed to them?
Yes, it was my secretary, who was supposed to deliver it. So it seems to be her handwriting.
Yes, but did you discover, did you not ask her whether that is her handwriting or not?
I did ask her. She confirmed, and then she wasn't too sure about it, but it was given to the messenger, she says. So from there, we had no idea where it's gone to.
So she didn't know who she gave somebody's title deed to?
Yes, she didn't know that, but normally it goes to the messenger who takes the documents to the respective parties.
So you don't know to whom it was delivered, but you are opposing the application.
I'm opposing because what I'm saying to him is that I offered to do it. I offered to get him a duplicate set of title deeds. So I didn't abstain from any form of responsibility. I took responsibility. I said, okay, fine, I accept responsibility. Let me get you another set of title deeds. It's a simple process. But he refused to sign the affidavit in terms of the regulations. So what I did, I drafted another set of regulations so that I can sign it, and I took responsibility. But it still required, the regulations still require him, as the owner of the property, to sign that that the title deed is missing, yes. So he refused to do that as well. So nothing was done about it from 2013 or 2014.
So is the basis of your opposition that, one, you accept that you did have their title deed with you up to a certain point, but at a certain point, your office gave it to somebody. You are not sure who it was given to, but you have offered as an alternative, you offered to obtain a duplicate title deed for
That's
them
correct.
at your own cost.
That's correct.
But in order for you to do that, you needed them to sign an affidavit because that's what the regulations required.
That's quite correct.
And they refused.
That's correct, Chief.
Okay, all right.
And then he refused initially because I wanted him to say he lost it, you see. Then,
Why did you want them to say they lost it if you
Because-
didn't know whether they got it?
well, that's what the regulations provide for. So then what I did, I changed the
They
affidavit.
can't say they lost it if they,
But
they
you worded-
didn't lose it.
Well, that's what the regulations prescribe. It prescribes that only the owner can apply. Okay?
Yeah,
So then the owner
okay.
must sign the affidavit in any event. So
Okay,
what I
all
did
right.
subsequent, a couple of days later or whatever.
Yeah, no, that's fine. MEC?
Just one question, CJ.
Yes.
When the CJ posed a question on the rule of law, your understanding on the rule of law, you said it seeks to limit the abuse of power and people not to abuse the offices that they occupy, which I find to be very limited understanding of the rule of law. Now, what is your understanding of the relationship between law and justice?
Well, law is what is on the statute books. Justice defines how you impose that law. So if in fact we have a law that's on our statutes, that's one thing. Justice is to ensure that the law is followed. And the forum in which that is ensured is the courts of law.
Thanks, CJ.
Thank you, MEC. Commissioner Matolo Tlepu.
Thank you, thank you, Chief Justice, and good afternoon, Mr. Laing. What I want to understand, were you the executor in this property or in this estate?
Yes, I was the executor.
And has the transfer been effected already?
Yes, the transfer was fixed in 2013, yes.
Into his favor?
Into his favor, yes.
Oh, okay, thanks.
Thank you, Commissioner. Justice Betze.
Thank you, Chief Justice. Mr. Laing, speaking for myself, I understand your explanation in relation to the lost title deed and what you propose to do in order to apply for a certified copy. But in the founding affidavit by the Naidus,
Yes.
they make allegations of, in effect, impropriety against you in that, in effect, you help yourselves to monies standing to their credit in their trust account without them authorizing you to do so. And in effect, or as a result, they lost out on interest that they would have earned eventually. Do you think that it would then be a wise thing on the part of the commission to recommend you whilst these proceedings are pending.
Commissioner,
Before you respond, let me
Yes.
just add this. From the explanation you gave earlier
Yes.
about how it came about, I didn't hear you saying, maybe I missed something, but I didn't hear you saying they had given consent. It came across as if you helped yourself to their money because you thought there was justification because they owed you and they had not paid the pro forma account.
No.
That's the impression I got of what you were saying.
no, it's in these papers as well, Chief Justice, that they had given me consent. And I explained it by them not paying the pro forma account shows that they had consented to me using their money for those purposes, because in a conveyancing matter, there are expenses to be met. And those expenses have to come from somewhere. In particular, the rates. The rates had accumulated quite a bit. So there are expenses that have to be made, and we normally give a pro forma account to the purchaser for him to pay. So the purchaser, Mr. Naidu, never ever paid that pro forma account. And that shows and adds credence to the fact that he gave me permission to use the money in his, that was in trust for those purposes. The money didn't come to me, by the way.
A follow-up, Mr. Laing. In paragraph 9.3, they make the categorical affirmation under oath that you withdrew a sum of 10,000, whereas the respondent was not entitled to make such a withdrawal, as we had not given our authority
Yes,
for such withdrawal to be made.
yes. There was no written authority. He's a colleague of mine. I did this work for him. I even gave him the opportunity to pull out the sale if he wanted to, but he was desperate for the sale, and he knew that we had no monies available. And that's why I don't know the reason why he brings it up only now since I've applied for this position. But he had all these years in which to do it. Nothing was done.
Hang on, Mr. Laing. Did he give you consent?
Yes, he gave me consent.
Was it written?
No, it was not written.
Was it verbal?
It's verbal.
That you can take out that money from the savings to the
Trust.
trust?
Yes.
So why do you think he's saying now he never gave you consent?
Chief, I just don't understand what his whole motive is in this whole case. If you read through all the papers, you would see, if you looked at my defense as well, you would see what's going on. I have my personal views, but I won't mention them now about him. I've never ever briefed him before. I've never had any relationship with him before. This was the only incident.
Did you say earlier on, because I seem to hear you to have said, by not paying the pro forma account,
Yes.
he gave you consent?
No, no.
Did you say something like that?
No, I said it that by him not paying the pro forma account shows that he consented. I'm just using that as proof to suggest that he had consented to me using the funds to pay for those expenses. Where else would the funds come from except from him?
So is it his failure to pay the pro forma account that you rely on to say he consented?
No, I'm just relying on that as proof that he had consented.
So when had he consented?
Well, it was around that time when we had to pay for expenses. That's why we drew the account, the monies from the savings account into the trust. There's no other reason for that.
Mr. Laing, if I were in your position, in that situation, I would have said to the Naidus, there's no way that we can attend to the registration of this transfer because the fees that you are supposed to pay as per the pro forma statement sent to you on date X has not been settled. And if need be, then you would have, if the deed of sale or agreement of sale make provision for cancellation of the agreement upon breach thereof, you would have given him notice to say, if this doesn't happen, this is the clause that you would invoke to cancel the agreement and hold him liable for whatever damages had been suffered, instead of you helping yourself to those funds because he hadn't paid.
Yes.
He makes this categorical affirmation,
Yes, I
and
think,
the matter is pending before court. And you ask why he is bringing this only now. And yet these proceedings, on your own account, were instituted on the 21st of April, 2021, long before this position was advertised.
yes.
And the Secretariat of the Judicial Service Commissions, once nominations were made and accepted, invited interested parties who wished to comment or lodge objection to do so. And this is how it came about that we have this document before us today. Thank you.
Thank you. I guess you have said what you wanted to say, Mr. Laing.
Yes, I think, well, if you look at the papers itself as well, and you look at my answering affidavit, you will see the history of the matter. I mean, first he accused me of not paying him at all. He makes a statement that I didn't pay him his interest.
Well, the point that Justice Burt is raising, and I think somebody else may have mentioned, I think the AJP is, it may be risky for this commission to recommend your appointment when there is this litigation pending where allegations are made, such as those that are made, in case the matter ends up with some adverse finding against you, it might not be prudent for the commission to go that route. That's what he's raising with you, and that is what the AJP was raising with you, to say, don't you think that you should have that litigation behind you before you can come before this body and ask to be appointed as a judge?
Yes, no, that's understandable. But, it's become a bit personal, I think, and it was raised at the time when I appeared before you on the last occasion in April 2021, and that's the time those proceedings started. And so I think it's
But
become personal.
you understand that the point being made is there might well be a risk in recommending your appointment in case that litigation with those types of allegations of impropriety against you turn out to be upheld by the court when you are already a judge. Is it not safer for this body to say to you, or for you to say, I would rather go and sort out my matters and I will come back later, should I decide to come back when there is no litigation hanging over my head?
Well, I think in all fairness, perhaps maybe if everyone could just read those papers and look at my defense and look at the reply, as long-winded as they are, not my reply, but the applicants.
Yeah, but I'm not saying you must take a particular decision. I'm just saying this is the essence of the concern that is being raised. Okay?
Fine.
All right. There was Commissioner Singh. Had I given you a chance?
No, thank you very much.
Then I've got Commissioner Tsepe and Commissioner Klaba, and I think I would like to then go after that to the commissioners attending virtually and close. Commissioner Singh.
Thank you, Chief Justice, and thank you, Mr. Laing. Firstly, I just see, Mr. Laing, you haven't responded to the proposition by the Chief Justice And I don't know if you want to remain silent on it or
Yes,
the proposition that you should consider, you know. Would you like to offer a comment on that?
well, that's why I
first before-
suggested perhaps maybe, you know, a brief perusal of the papers may show the validity of my defense. That's all I can say, you know, but I suppose with proceedings pending, it's not fair to the judiciary to have those proceedings pending against a judge that's appointed. But in the same breath, there's also other cases, so I don't know how to explain these things.
I guess, Commissioner
Okay.
Singh, that's the answer.
Okay, thank you
Yeah.
very much, Chief Justice. I'll then proceed with my question. I really thought people of the same ilk would find each other, you know, and through arbitration and through settlement, etc. But I'm quite surprised. In fact, I think the acting JP, I was going to raise this matter, but he canvassed it very, very widely, so that's good. I just want to refer to Mr. Laing, your questionnaire and section 2 in particular. Legal background. You know, that's on page 6 or 8, whichever way you want to look at it. And read that with 625, where you say that 10% of your work, litigation work, is family law and divorce.
Okay, what paragraph is that one?
625
Okay, sorry, I'm looking at the wrong.
in your questionnaire. You state that 10% of your litigation work is family law and
Sorry,
divorce.
that's the wrong one again. 625.
Yeah, 6.2.5.
62.5 or was it
No,
600?
6.2.5, and it will be on page,
Paginated 12.
yeah, that's a word I was looking for, Commissioner. Your lawyers use that word. I would have said 10, page 10. Have you found that?
Oh, this is Harilal. I think this relates to Harilal.
In any case, but that's what's written there. So you've said 10% of your litigation work. But then on paginated, now a new word, paginated 9, Roman numeral 4. I don't know if you've got
Okay, let me look at my bundle rather to prevent any confusion. Okay, on the questionnaire,
Yes.
paragraph.
Paginated 9, Roman numeral 4.
Okay, no, thank you. Yes.
You've stated something there, and I just want to know before I remind you what you stated, whether this is a personal view, a religious view, or a legal view,
Yes.
where you say in the last 10 years I've shifted my focus towards civil litigation and family law. I believe that stable families make up stable communities.
Yes.
I am concerned about the breakdown of relationships and the ease with which divorces are granted. A more conservative approach should be taken in the granting of divorces.
Yes.
Now, I would take it you get a number of divorce applications before you, and there are circumstances like unhappy marriages, abuse, and things like that warrant divorces.
Yes.
I'm just trying to understand what you say here, that a more conservative approach should be taken in the granting of divorces.
Well, the test is whether the marriage is irretrievably broken down. Okay? And it's very easy to grant a divorce. There's two aspects to it. The one is from the judge's point of view, and the other from the attorney who's acting in the matter's point of view. So I'm suggesting that because we need a society that's stable, if you have a society that's broken down by the separation of mothers and fathers, you have a society that's ungodly society, if I may say that. You have a society that's a confused society. You have a society where children
Sorry, I
have
didn't hear the word before. Ungodly, you said.
yes.
Ungodly society.
Yes. Marriage, where there are marriages, a society is stable because there's a family structure in place. Where there's been an abandonment of responsibility, either by the mother or the father, you find there's conflict. You find the children go astray, and with the result, it affects the community. So the stability of any community depends on the strength of the family in that community. That's my personal belief. So it's important to protect families. It's too easy nowadays to get a divorce. From a judge's point of view, it's granted easily without some investigation being taken place into reasonable prospects of reconciliation. So I'm of the view that there should be some attempt to try and keep the family together.
No, I certainly agree with you about family values, just as of family values and keeping families together. But I was surprised that this kind of comment comes from a person who's applied for a judgeship. So when I read that, it just rang a bell. Thank you. Thank you, Chief Justice.
Thank you. Commissioner Tsepe, I've got Commissioner Klaba and Commissioner Nochesi, and after that I would like to stop and look at the commissioners who are attending virtually, and let's see if we can wrap up. Commissioner Tsepe.
Chief Justice, you'll be happy to know that Commissioner Singh raised the issue I wanted to raise about this issue. But I just want to say, I'm still not sure what a conservative approach in a constitutional democracy means.
Yes.
And it does concern me, Chief Justice.
Yes.
I've heard Mr. Laing's answer, but it still concerns
Yes,
me. And I'll
but
leave it there.
he has
Yes.
given his response, yeah. Okay. Commissioner Klaba?
CJ, I'm also on the same question.
Yes.
I mean, the question, does this not create a reasonable apprehension that you may be biased against the litigants in a divorce application?
No, actually, on the contrary.
Thanks.
I think on the contrary, I think I'll be helping them to solve their problems. Because if you, as the presiding officer in a potential divorce matter, try
Well, I'm sorry, Commissioner Klaba, I wonder whether you expect a different answer from the one he gave to Commissioner Singh.
Maybe let's leave it at
Yeah,
that.
he has given a
CJ.
certain
Thank you
answer.
for your guidance.
It might or might not satisfy, but that's his answer. Commissioner Nochesi?
I've also been covered by.
Oh, you have been covered. Commissioners attending virtually, is there anyone who has a question? No one.
None from me, CJ.
Thank you.
I have no questions. Thank you, Chief Justice.
Thank you, Commissioner Breitenbach. Thank you, Commissioner Barnard. Thank you.
He's listening.
No. I said no questions from me, Chief
Oh,
Justice.
okay, all right. Okay, all right. Thank you, Mr. Laing. We have come to the end of the interview. We thank you for availing yourself. I'll give you 3 minutes for you to emphasize any points, any 2 or 3 points that you might wish to emphasize, that you think the commissioners should particularly pay attention to when they consider your candidature. But it's fine also if you consider that important issues have been dealt with adequately.
Yes, perhaps I should just say, I want to thank the Lord Jesus Christ for giving me an opportunity to appear before this esteemed commission and in order for an opportunity to serve my country. And secondly, perhaps I would like my God to bless you with wisdom and direction in your endeavors to protect our judiciary. Thank you.
Thank you very much.
Thank you.
Thank you, Mr. Laing.
Thank you.
You are now excused.
Thank you. Can I have a sweet?
Thank you.
I have two.